I know, but children shouldn't be here in the criminal district court to watch their parents have to deal with criminal problems. But I guess sometimes that's nothing we can do about it. I mean, an infant and a little child is here in court. That's their earliest memories of life. You bringing the family in?
I don't got nobody to watch them, so I like to tell them. I gotta do what I have to do.
I know, but children shouldn't be here in the criminal district court to watch their parents have to deal with criminal problems. But I guess sometimes that's nothing we can do about it. I mean, an infant and a little child is here in court. That's their earliest memories of life. Yeah. Okay, John, help us out here. You're a good man. How can you pull out of this nosedive?
Oh, we're still working on trying to get a resolution in this case, Your Honor. This is I believe it's a DWI.
Is it one of the children? It was a DWI with the child passengers. Is that the little child that was in the passenger? Or
You said it right.
was that the passenger or was it this infant? How old is the infant?
He just made some.
At 3 months?
2 months.
2 months. Isn't a place for,
Well,
All of this.
We said we're out here. Going for the next thing.
well, what are you going to do today? It says an announcement.
And yes, Your Honor, we're still working on trying to get a resolution in this case.
Well,
We're trying to-
Hmm.
We have a probation on the table, We're trying to see if we can work something that may prevent a conviction for her. She can't get it with her for this type of charge.
Right.
That's also what we're trying to get to.
Who's the attorney on that?
Mr. Eckert.
Hey, Joe.
A few more weeks, yeah,
Is one of these the complainant?
or the child in my car, yes.
What was John, was there an analysis done? It's talking about intoxication here.
I'm looking, Judge. I don't know yet.
Says the defendant was intoxicated, so, and there was a wreck. And the 1-year-old was just in the car loose. Is there a blood analysis or something that was done here?
I don't know. I'm looking. I don't have it on there.
What do you know?
I don't remember if there's blood tests or not. I know it was an accident and then my discovery up here. I don't have my laptop with me. I didn't read it today. So I'm not being able to get on. So we'll depend on Mr. Eckert.
The BAC was 0.160, Your Honor.
There you go.
Thanks.
Twice the legal limit. Who takes care of the child when you're not around, man?
Nobody.
Well, you're going to end up going to jail on this. Probably. I mean, it's mandatory.
Which time, yeah.
Yeah,
Well, it
for
depends
just
how we-
unless it's dismissed or reduced. But under this charge, you're going to go to jail. At least for.
It's 20 days. Is it 20 days?
10.
Okay.
So you've got to start making arrangements. That doesn't keep you out. Somebody's got to take care of the 2 little children, but
That's one of the things we're trying to work on. Trying to see if we
Uh-huh.
can some kind of-
it's got to be, the children are going to go into jail with you.
Well, also if we can, there's other ways to resolve it, get around that. That's why I'm trying to.
What way was that? Under this charge?
Under that charge, right?
Okay.
No,
All right.
under a different
That's all right.
charge. You could use some other kind of charge like endangering a child, which is the same crime, but in the same elements.
I know, but I know, but these are bad facts.
Oh, yes.
Okay, All right.
That's why I did.
But
If it was easy-
the state can do what they want to do, but these are bad facts.
And if they're easy facts that everybody had it resolved, that's why it's taking a little longer to get the state to do something different. We might not get anything done different, but that's what we're trying to.
Okay, on, Pia Ballard, come on in. You just get a reset. Or,
30 days,
yes.
Yes, please.
Mr. Deuce, or what he's gonna be.
Have you talked to Mr. Dusler lately?
Yes, he said he's out.
He's out.
Yeah, he
Well,
was
if
the
he'd only
public
tell us, I'm glad he's talking to you, but he's not
I had
talking.
to call his office.
That's a shame. It's. What did he say?
He said, I talked
Not,
to
not
his-
anything
No, I talked to
about
his,
representing you,
secretary. He said he could be back
secrets.
next week sometime.
Did he call us?
I didn't speak to him.
She said that, when I called her on Monday, she said that y'all would know he was out and that he wouldn't be back till next week.
Well,
sometime.
clairvoyance has not been my strong point. I mean, generally, people should tell me.
Yes, sir.
Yeah,
Judge, and he may have spoken to Ellie. I did not speak to him.
well, but
Um,
when we're sitting there spinning our wheels, I mean,
she does need to fill out an initial form, this is an initial appearance. So now that she's bonded out, she needs to fill out.
Are you- okay. Are you able to hire a lawyer?
Yes.
Why not?
I don't have the extra money at the time. I
Yeah,
just have a part-time job.
that's why it's always a good idea to not get in trouble.
Yes, sir.
Because that thing gets you caught up
Yes, sir.
into a money situation. You need to fill out one of these indigent forms, please.
Yes, sir.
We have to have that by law so that someone can be appointed like Mr. Dusler. Who is Mr. Dusler?
He was on vacation. She was an initial, so I went ahead and kept it on the docket so that we could go ahead and. move
Okay,
forward with
we
it.
just, nobody
She
told
needs
me. I'm sorry.
That's why he hasn't. been on
I
the
don't know.
dockets.
I was gone all week. I don't know what's going on. I just said, I take it day by day here.
Yes, sir.
You filled this out?
Yes, sir.
Who's this judge?
Are you married now? Okay, there's no other income other than just yours into the household?
Yeah, I stay with my grandfather. So I just pay him whatever.
She has the file, right?
Yeah.
Like a second, all right.
Is this Ballard, Judge?
Yeah.
It is.
Okay.
All right, the court is declaring you indigent and an attorney will be appointed to help you resolve this. Okay, so,
Mr. Deuce or so.
yeah,
Set it 30 days.
yes. Here's, what are we doing? Here's Miss Ballard. Filing here.
Thank you.
Here's Lemarian Dean's file as well on Mr. Grove, who's now here. You're Miss Taylor?
Yes, sir.
In 235725, you were charged with interfering with child custody. This is a state jail felony, which carries with it, if convicted, up to 2 years in the state jail. So it's serious. It's a felony. And do you have an attorney?
No, sir.
Why not?
Try to get an appointed court, appoint.
Why? Why should the taxpayers pay for your mess? You've been indicted. You made him. You may have made a mistake. The grand jury says you did, but you're presumed innocent. But like everybody else, we're supposed to fix our own mistakes. Why? I'm a taxpayer too. I don't want to pay for a free ride for you. You need to pay for yourselves. When you make a mistake, you get in trouble. You got to fix it yourself. That's the way I grew up. That's the right thing to do. Not others carry the ball.
Yes, sir, I understand. And that charge came in 2020 and I didn't know that was,
Yeah, this is old.
yeah, I didn't.
Hey, this says you lived at 2611 6th Street, is that right?
Mhm.
You still do?
Yes, sir.
And when did you get arrested on this?
I got arrested this year because I went to go pay a ticket and they said that I. had
There was a warrant or something?
And I wasn't
You
notified.
never knew about it?
No, sir.
Looked like
That's-
the warrant was issued in October 28th, 2020, and then let's say there was booked on March 14th, 2025. So it wasn't until
4.5 years.
But in 2020, I had custody on my daughter.
What does that matter? You're charged with a crime. This isn't a
I don't know what the
trial.
charge- I don't-
Yeah, this isn't a trial. This is just the grand jury indicted you for interfering with child custody. Whatever the facts were. I don't know what the facts are
That's
on
what I
that.
and I didn't.
Hold on. Both can't speak over each other. When I speak, you gotta stop. She can only take one at a time, and if she's not able to get everything accomplished, the court reporter, because two people are speaking over each other, the Court of Criminal Appeals has said somebody's gonna get in trouble. It's not gonna be me. It's gonna be you. Let's don't speak over each other. And when I speak, you've got to stop because I've got to figure this out here. Okay. So, this isn't a trial, but it is an odd thing that it's taken so long. Especially since you've been living at the same address. That's weird. I mean, they know where it's not, you've flown the coop and moved off to another country or something. This is weird, but sometimes this happens. You got to deal with it now. Are you employed somewhere?
That's what I wanted to address. I worked for the county for 2 years and I got 2 background checks. One for the company that I work for and one for the sheriff's office, and they both came back clean. So
Yeah. Which goes to show you a warrant is going to be clear. When there's a warrant issued after an indictment, it's in the records. And maybe the people who were doing the background checks didn't do a good job, because that's odd. This should have been discovered a long time ago. But warrants are issued after indictments. They're done routinely. And the fact that people did background checks and didn't discover you is something else. There's something dropped, the ball was dropped somewhere, but nonetheless, those people who may have dropped the ball aren't charged with a crime, you are. So it's your situation you've got to work with. So where are you working now?
I'm no longer employed because of the.
Okay, you don't have an income?
No, sir.
You need to fill out one of those indigent forms, okay? And then if the court approves, then an attorney will be appointed to represent you. This is just crazy. I don't know how many mistakes can be made in one situation like this.
Stigma allegation.
How long is this gonna take? Is it long or succinct?
10 minutes.
Go ahead.
It's pretty quick. Yeah.
On around ATF. Around ATF.
Sounds like they may want to do a plea, the one you're just calling.
This one?
Yeah. It was his attorney.
Mr.
He's
Oh,
out
it's
of
the
town.
same last name.
They're not related. I've asked before.
What are the odds of that?
It's a popular name.
It is. I've never heard of it. I've heard of Smith and Jones. ATF. Anything can happen. What are we gonna do on Mr. Atia?
I guess, sir, essentially, I went over the offer. We are
Yeah.
in agreement. We are in agreement, Judge.
You want to dispose of it today?
Yes, sir.
Okay, can you fix it up and
Absolutely. I was just.
thank you, sir.
Yes, sir.
I see both of y'all have the same last name.
Yes, sir.
What are the odds? Sir,
Not related though.
not related
Yes,
though.
sir.
The background is what?
We're both Pakistani. Both
Oh.
Pakistani. Yes, sir.
Oh, Kia Ale. Hey, Dr. Aziz is my doctor.
Oh, really? We know them.
Mohammed
Yeah.
Aziz
Yes, sir.
and his wonderful wife. Yeah, they're very good friends.
We went to the same church.
Oh, do you?
Yes,
Oh,
we went to the same church. Yes. sir.
okay. Well, yes, wonderful, a good family friend of ours. Yeah, and he's my doctor. Yeah.
Yes, sir.
Well, but welcome and shukriya. Thank you for being here. Dr. Aziz teaches me some words.
I'd see. Are here.
Is that an extra fee?
Hey, son.
I'm not gonna tell you the way you, you speak like an Arab. Tells me that, like an Arab. I don't know if that's good. Okay, 23-41359 is called the state of Texas versus Robert Lee Stroud. Yes. Mhm. Yeah, I would be too. It's never, that's a terrible. Okay, you are here with Mr. West, your attorney, right? All right, in cause number 23-41359, you were indicted back in January of 2023 for the third-degree felony of evading arrest or detention with the use of a motor vehicle. And you pleaded guilty to that charge in January of last year, 2024. We placed you on 10 years deferred or unadjudicated probation. I think you went to the Safe P program, substance abuse felony punishment facility. And you were ordered to go there and complete the program. Apparently that was not accomplished. And on May of last year, a year ago, a motion to revoke unadjudicated probation was filed by the criminal district attorney's office. And this is the motion that we are going to be dealing with. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, Sean, please.
Mr. Stroud, this motion to revoke unadjudicated probation in summary states, and by the way, raise your right hand. Raise your right hand. Do you solemnly swear or affirm any statements you make will be the truth, the whole truth, and nothing but the truth? So help you God during this hearing. All right. That's okay. Yes, that's affirmative. All right. This states that on January 25th, 2024, in this court, you were placed on 10 years deferred or unadjudicated probation for this third-degree felony of evading arrest or detention with the use of a motor vehicle. Is that true? I'm sorry.
Yes,
It is true? Yes, sir. Okay. Allegation one, the only allegation here it states that you violated your probation by failing and refusing to participate in the substance abuse felony punishment program as ordered by the court in violation of condition 12 of your deferred or unadjudicated probation order. Is that true? Okay. Okay, have a seat. Well, we're gonna have a hearing. He denies it. You, sir? Let me ask you, John, is there something wrong? Do we need an examination or something?
He was just found,
Because I said,
Your Honor, on
that he was
April
incompetent.
11th,
And you-
from the Dunn Behavioral.
I still believe he's incompetent, but
Yeah.
the doctor says he's competent, so that's all I hear.
Yeah, well, I know, but he's rambling and is incoherent and it continues to rudely interrupt the court, which is against the rules. He's not following rules and he's mumbling and he seems incoherent. What do we want to do? Yes, you are, sir. When I speak, you have to stop or else you have to go back to the jail and you're put in detention. We don't want you to do that. Go ahead.
Your Honor, I don't believe he's competent, but the doctor's report and has ruled that he's competent, so court is not-
Can you explain, is there any explanation you can make for the way he is acting now, if he is competent, for the record.
I
We've
can,
got to have something in the record that supports something other than the way he is manifesting
Your Honor, this-
himself now.
I will say that every time I spoke to him, it's very similar to this, that it doesn't make a lot of sense. It's incoherent. He is not very easy to communicate with. I still do not believe he's competent. And I know the doctor ruled that he is competent. I'm not a psychologist, don't have a degree in that, but I don't, you're not able to coherently understand what's going on.
I hear what you're saying, right, and justice come on, like, just feel not guilty, that's what you're saying, I feel I'm guilty. I hear you, loud, yeah, it's just jail, it ain't me, man. You stay at the jail right now, telling you like you educated. I'm educated, you in there, girl, man. I'll let you speak over me.
Don't be rude. Don't be rude. Don't be rude. Hold on. Don't say a word. This court's reading something. You'll be able to speak here in just a moment, sir. Thank you. Are you taking your medicine? They're giving you medicine?
Take no medicine for the word for BC powder.
They're not
Medicine
giving,
you have a little bit coming straight off.
John, he's mumbling. I don't understand it. It's like in a different language. Is he taking his medicine?
He's a no.
Is he being administered medicine?
I don't know if they're doing it or not, but he's not, according to him, he's only taking BC powder. Is the only thing he takes. That's all he needs.
BC, that's for indigestion?
That's kind of like a general.
I think for headache.
Yeah, it's just kind of like a Tylenol.
See, it says here in this evaluation, and I'm looking at a report dated April 15th, 2025. A month ago, it was prepared by the University of Texas Health Center at Houston. And this is an evaluation of the defendant by signed by Dr. Daniel Doyle, Chief Operating Officer. It was a very lengthy report of a report of competency and attending physician's report of the defendant, signed by a psychiatrist, Nicola Polizzato, Polizzotto. And this report consists of 13 pages of single space text of the result of the analysis of the defendant and the opinion and recommendation summary on the last page of this report in the portion called attending physician's report of patient's progress. The treatment team's opinion of Mr. Stroud is he has achieved maximum benefit from inpatient hospitalization, and he should be returned to court as he is competent to stand trial. It should be noted at the time, no known prior history is noted, but at the Jefferson County Jail, while he was there before they had analyzed it, the defendant was described to be disorganized and internally preoccupied. Well, that's what he's doing right now. He was not started on medications and presented at GCB with no sign of improvement, appearing also grandiose. At first trial with Haldol, up to 30 milligrams daily led to just a partial response, and similarly, olanzapine up to 30 milligrams daily also led to improvement, but some degree of disorganized persisted. He entered Safe P and began his treatment, but quit it on April 22nd, 24. So he was reincarcerated in May of 24. He was prescribed olanzapine, 10 milligrams, but it seems he was most recently non-compliant with taking his medicine because he seems disorganized and internally preoccupied, like he is now here. Given his history of partial response with failure of olanzapine, it was attempted to prescribe a combination of olanzapine up to 30 milligrams daily and Invega up to 12 milligrams. Again, disorganization with illogical, nonsensical statements or neologisms appeared difficult to treat. However, he made further improvement over what observed before, and while some disorganization persists, he is now able to communicate relevantly. His behavior seems appropriate, and he has displayed fair participation in the program. He has clear benefit from current medications. It is strongly recommended he continues to take psychotropic medications as prescribed. Currently, is not a threat to himself or others, and a civil commitment is not being pursued. It seems like the issue is ensuring that his medication is taken. Are you taking the
I'm
medication?
not taking the medication.
You're not taking any
When I tell
medication?
them I don't take it. I don't take it. I don't want that in my body. I don't want that
Okay,
in-
did they give it to you though?
I take it at nighttime. I don't take the
How do you
blood
take
pressure.
it?
I take it with water.
With water? Okay,
So, like,
all right, okay. So back to this,
I ain't trying to do this one.
back to this allegation. This states, Mr. Stroud, you refuse to participate in the Safe P program as ordered. Is that true?
Yes, I ain't gonna tell you none of it. I ain't
You're not gonna do
none of
that?
classes. I ain't gonna
Are
do
you, are you pleading true to this
that. Yeah, I'm trying to get this shit straight.
voluntarily and because it is true?
Yeah,
Okay, do you understand
yes, I understand.
that,
everything.
hold on, let me speak, that a knowing and voluntary plea of true, that is to a violation of program probation, that is enough to grant this motion to revoke probation. Your probation could be revoked. You could now be found guilty and sentenced no less than 2 nor more than 10 years confinement in prison. Do you
It
understand?
should be time served for the offense.
Do you understand what you're facing?
Yes, sir, yeah.
Because you've got a lot of time served. You got almost 700 days. Yeah, almost 2 years. Knowing that, knowing all of the consequences possible, do you insist on pleading true today, like you've done? Okay. I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true here. Go ahead, John, what are you asking for?
Your Honor, we're asking for, just like you said, we're asking for credit for time served. He's already done.
What are you asking? Credit for time served? Give me a number.
2 years.
That you're asking for the minimum.
About 2 years.
Okay.
He's gonna have credit to cover that, and I think that would be a fair number based on his offense.
Just looking for a pre-sentence report really quickly. See if I can help them. Dan, what are you gonna do when you release? Where are you gonna live?
Back in my, behind Jubilee about a mile.
Okay.
Go back over there.
Here's the criminal history.
And like you got a whole phone right here, but I watch the beach this phone. I live, and when I leave, I live.
Okay, he's never been convicted. Looks like it was felony, huh? It's just been,
As far as I
he's
know,
been
he's-
placed on probation for controlled substance violation and evading arrest, this one, and illegal possession of controlled substance twice. So he's been on 3 different deferred probations over from 2007 to 2022.
And he also had the, sorry, Your Honor.
Thank you.
John, is that the review?
Yes, that's what I want to go to get the conviction of felony convictions.
And then it's got a numerous misdemeanors,
Yeah.
but nothing, but they were only short terms in jail, resisting arrest. Okay,
So that's why I'm asking 2 years, because it's a type of offense.
All right.
It's not a.
What's-
offense.
state
State would recommend 4 years, Your Honor. Just 2 third-degree felonies. I mean, that's kind of still on the lower end, but I'm recommending a 4 year.
And Mr. Stroud, anything you'd like to say?
No, sir. I told him, man. Okay.
Yes, sir.
You see, he was just love my world and coming there to the head, man. I got the head power to do it. You mean, finally, whatever that was saying,
Okay.
for real.
Okay, all right.
I think to translate a little bit about that, I think his issue is that he stays out of trouble and on his probation, the only violation he does have is not going and refusing to commit safety. He hasn't committed new offenses or anything like that. So I would understand.
Before I assess a resolvement in this case, the thing is that what we want to do is fix the problems. And if Mr. Stroud does not take his medicine, then he's going to be right back into, we're going to revolving door and something's going to happen here. Here, it was evading arrest and detention. He was, on this case, that he's placed on probation on, he's operating a 4,000-pound missile around town. Anybody feel safe with that?
I had my car.
I understand. I understand, sir, but a vehicle, I know a vehicle has to be operated responsibly. Yes, sir. And-
Roll it, just-
All right.
The other option is to continue on probation.
Second copy.
What's that going to do?
Yeah,
for
so I
us?
don't think that'd be successful.
All right, here's what we're going to do. I'm going to find there is sufficient evidence supporting this motion to revoke unadjudicated probation, to grant it by a preponderance of the evidence or greater, as allegation one has been proven true, as the defendant has admitted, that he has failed to participate knowingly in this SAFE-P program, substance abuse felony punishment program, as ordered in violation of condition 12 of his deferred or unadjudicated probation order. Early in this case, the defendant pleaded guilty voluntarily. He was mentally competent to do so. He understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting his guilty plea to find him guilty beyond a reasonable doubt. I now find you, Mr. Stroud, guilty of this third-degree felony of evading arrest or detention with a motor vehicle that you were placed on probation on, based upon this motion to revoke unadjudicated probation hereby being granted today in this hearing. And you are found guilty beyond a reasonable doubt of that underlying charge that you were placed on probation for. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. And you will be given credit for all time you have served, which is 2 years. So it sounds like you may be getting out here.
8 more months ago.
No, not necessarily. No, it's nothing. You may be getting out pretty quickly here because you're parolable, and very few people stay in prison, stay in a jail for the whole time. You get parole, and parole is generously given. So you might be released here shortly. But you're going to be given credit for at least 654 days, which is right at 2 years. Okay. Anything else? All right. Good luck. Good luck to you, sir. Thank you.